Kia ora koutou. Ko Angela Caves toka wingua, no mai haere mai. Welcome to the Tairāwhiti Business Growth and Support Virtual Conference. My name is Angela Caves and I am the Partnership and Events Lead with Digital Boost. It's my pleasure to be hosting you this afternoon on day 3 of our conference, our third and final day. Welcome to our audience who have joined us in the webinar, and a warm welcome to those who are joining us via a live stream on either Facebook, LinkedIn or YouTube. We had 2 wonderful days just previous to this. We have had a number of organisations join us, sharing the breadth of support that is available for the Tairāwhiti business community. On the webinar with me this afternoon, I have got my co-host from our collaborating organisation. So Robin Barker is an Employment Liaison Advisor from connected.govt.nz. Robin is based in the Tairāwhiti region, so is there to lend a helping hand in person if you need to go and speak with her. Robin's going to take you through our housekeeping and then introduce our lovely guest presenter. Thanks, Robin. Lovely to have you this afternoon.
Oh, kia ora, thank you, Ange. Kia ora koutou katoa. For those joining us in the webinar, you can see and hear us, but we can't see you nor you. So please feel free to add any questions or comments into the chat or by using the Q&A function available. We'll address any questions towards the end of the presentation. Our sessions are being recorded and will be uploaded to YouTube playlist on the Digital Boost channel for post-event viewing. All registered attendees will be provided a link to this via email. It is now my pleasure to introduce Vinod Daya. I hope I pronounced that correctly, Vinod. He is a Senior Engagement Advisor for employment.gov.nz. Over to you, Vinod. Kia ora.
Kia ora koutou, everybody. I'll just practice we'll test the screen share. Everything's going fine. So are the slides coming up okay?
Yeah, looking great. We'll leave you to it, Vinod.
Can hear me okay, nice and clear?
We sure can.
Okay, so kia ora koutou, everybody. Thank you very much for attending, whether you are watching on social media or picking this up in the recording, or you come into the session a little bit later. It's a real honour and a privilege to be able to support this series and reach out to our stakeholders in Tairāwhiti, Gisborne. We'd just like to say thank you very much to Angela for Digital Boost and Robin for Connected for giving us the opportunity to support the series. I'll just run you through the slides, and if you have any questions, pop them into the chat. I think Angela may have some questions at the end and we can cover them then. So we're Employment New Zealand. We've dated the slides 14th of October. Just remember, if you want the latest information, refer to the Employment New Zealand website. Today we're going to provide you with information on your employment rights and responsibilities, and I think there's a huge benefit to your business. It can help you be a fair and compliant employer, and that can help both your business and your staff to succeed and prosper. Here's a roadmap of what are the things we're going to cover. I just give you a bit of an intro to Employment New Zealand, cover some rights and responsibilities, options for resolving problems, talk about the lots of free and amazing tools that we have and resources we have available to help you, and where you can get some information and support. So you may have heard of Employment New Zealand. We have a website. It's called employment.gov.nz. It has around 6 million visits a year, and we're very active on Facebook and LinkedIn with over 200,000 followers. You also may have heard of some of the services we provide in the public domain: employment mediation services, which we'll discuss a little bit later, and the Labour Inspectorate. So while most employers are good employers, like the people who are watching this webinar, there are some employers out there though who don't comply with the law, don't comply with minimum employment standards, and this is where the Labour Inspectorate, as the enforcement side, come in and enforce that those minimum standards are met. just going to highlight some of the key things to help you when you're running your business or starting it up, because when you get these things sorted at the beginning, it prevents you from having problems later. So these are just some key points. One of the tricky thing is when you're trying to hire your staff, what employment status do you hire them as? So the key things to understand is when someone is an employee and when someone is a contractor. So make sure you get that sorted up front and get it right. I'll run you through some notes and give you an example. So who is an employee? Technically, it's anyone who has agreed to be employed under a contract of service. If it's a contractor, it's called a contract for service. But employees contract of service, which means an employment agreement to work for some form of payment, including wages, salary, commission, or piece rate. So see that? Some form of payment that's more than just wages. And it includes a whole bunch of things. Full-time, fixed-term, seasonal, casual, and part-time. Employees on probationary trial periods, home workers, and when the people have been offered and accepted a job, not started the job, but they're still an employee. Employee is not a self-employed or an independent contractor or a volunteer who does not receive a reward for working. So as we know, looking in the media, the difference between an employee and contractor can be grey. So we know that with the case of Uber drivers, some places around the world they're considered employees and some places they're considered contractors. So to help clarify for yourself when you have one of these situations where it's not really clear, we'll run you through some legal tests that the courts have provided. So employee versus contractor, use these legal tests. So imagine our business is hiring someone as a gardener. First we do the intention test. Is the aim for the worker to be an employee or self-employed? A contract for services rather than an employment agreement implies a contractor, and a contract implies a contractor. And if there was an employment agreement, that would imply an employee. Control versus independence. Will they be supervised? So the more control we have over our gardener, over their hours, work and methods, that implies an employee. Less control, contractor. Integration. Will they be part and parcel of our organisation? No, then that implies a contractor. If they were working for us lots of the time, doing a huge amount of work, really integral to what we do, that is going to imply an employee. And then we use the fundamental economic test. So what is the total situation? Not just the superficial things, but deep down, what's actually seems to be happening here. So for example, if the person works for many businesses for fees, that implies a contractor. If they're just working for you, that implies an employee. So there's some of the legal tests. Make sure that you are clear that you're hiring people on the right basis. And if you're not sure, reach out to Employment New Zealand, and we've got some services that can help you, give you some contact numbers at the end of this presentation. Employment agreements or the employment contract. These are some other fundamental aspects to make sure you've got these in place. So all employees by law must be given a written employment agreement. So that means at the start of the employment negotiations, when you're offering the person the job, you've got to offer them an intended employment agreement, give them reasonable time to read it, understand it, ask questions, and then it should be signed, and then they should start the job. And then once that contract is in place, it should be any verbal agreements that you and your employee agree to, make sure that they're recorded in the employment agreement, and you have to have that available whenever the employee would like to see a latest copy. And there's also some mandatory requirements that must go into an employment agreement. So must have the names of the parties, must state the duties, which you can state in the job description, what the worker is expected to do, their place of work. Nowadays, it would be important to also note where the person can work from home, etc., or whether they're coming into the office and where, or the place of work, the hours of work, their wages and salary, remuneration, time and a half. So just notes that when people work on a public holiday, they must be paid at least time and a half. And there's employee protection provisions for people who are vulnerable workers in particular industries, and process for resolving employment problems. So the good news is that we have a tool called the Employment Agreement Builder tool, which I'll show you a little bit later. And you can just use that tool. It's a free tool. Create your own template, and then you'll have current and legally up-to-date employment agreement template to use. Just going to note next what we call some key minimum employment rights. These are also minimum employment obligations that you've got to apply. They're also called employment minimum standards. So they're basically things that are in the legislation that parties can't negotiate out of. It doesn't matter what parties may have negotiated. These things always must be adhered to because they're in the legislation as absolute minimums. So we have minimum wage rates, and the current adult rate is $21.20 per hour, and it's since the 1st of April 2022. If these things change, and they have been in the recent past changing each year, they change with effect of the 1st of April. And there's also rates called the trainee rate and the starting out rate, which is 80% less than that. Just go to the employment site and pop in minimum wage if you want more information. Public holidays, employees get 12 public holidays per year. It's just increased recently from 11 to 12 with introduction of the Matariki public holiday. Key things to note: if a person normally works on a day and that day is a public holiday and they work on that day, they're entitled to the time and a half. Because it's a day they normally work and they work that day, they're also entitled to an alternative day off. If they work that day, but it's not a normal day that they work, then they don't get that alternative day off. Annual holidays, that's for people to get rest and relaxation. So after 12 months, people get four weeks paid annual holidays. And there's a lot of other rules around there, like how much you can cash up in advance, how much notice is required. So if you've got more information, check out annual holidays on our website. Sick leave, recently increased, the annual entitlement kicks in after 6 months, recently increased from 5 days to 10 days. And once again, to see the conditions and how it applies, check it out on our website. At the moment, it's 10 days per year after 6 months. Bereavement leave. So this is quite a tricky one. So I'm just going to take you through it with some examples. Bereavement leave, you get entitled to that after 6 months. And the bereavement leave is based on each bereavement. There's not a cap to how much bereavement leave you can use. So if a person, if our employee, they suffer a bereavement with someone really close to them, like a child, a brother, a sister, a parent, a grandparent, that's a close relationship. So for each of those bereavements, they're entitled to 3 days bereavement leave. And then if it's someone where they have a special relationship with, it might be a cousin, an uncle, or a special friend, some cultural or historical reason, they can clear that with the employer. And for those sorts of bereavements, it's 1 day per each bereavement. And that's not per annum, it's just per bereavement. So someone in 1 year may unfortunately have a number of bereavements, and on each bereavement, they're entitled to either 3 or 1 days. So domestic violence leave is actually called family violence leave now, and that starts after 6 months. Unfortunately, if someone suffers from domestic violence, they are entitled to 10 days per year leave. Rest and meal breaks, these depend on the hours worked. So a couple of years ago, the law was strengthened to bring back these rest and meal breaks as legal minimums. And they're set up in legislation. There's a schedule there, and it tells you, depending on how many hours you've worked, how much rest, how much meal break you're entitled to. And it's done what's on a reasonable and practical basis. So let's just say we've got our worker, we hire them, they work for us on an 8-hour shift. they're entitled to a morning tea and an afternoon tea, say 10 minutes would be about right for industry custom. Those two rest breaks would be paid breaks. And then they should be entitled to a meal break, which is unpaid time. That would be 30 minutes. This is all based on what's reasonable and practical. So if you have someone, maybe you have an airline and you have pilots, or you have someone and they are running a retail store for you and it's just one person, might not be practical for in those circumstances to do things as per the schedule. So you work something out that's fair and reasonable. When the parties can't come to an agreement, then you can refer back to legislation as to what the minimums are. A union, so employees have the right to join a union, and they shouldn't be pressured either way to join a union. It's up to them to decide what their preference is. And dismissal and redundancy, fair and proper processes must be followed in these particular situations. Very stressful for everybody if you have to let someone go or your employee is going to lose their job. Some general employer responsibilities, we'll just cover those. Some of these things that all employers must do is they must provide that written employment agreement, which I've covered. They must provide their worker with a safe workplace. So when the worker starts, explain to them what any hazards are, what the policies are, processes for reporting any incidents, proper training, and just having a really good safe environment. It's all the employer's responsibility, and it's not the employee's responsibility to buy PPE, protective equipment. That's the employer's responsibility. We've also got to provide like a safe environment in terms of like harassment and discrimination, being free from that. So as an employer, your work environment should not allow bullying, discrimination, sexual or racial harassment of employees. It's not just something for the staff, for the managers and the owners, it's also for the whole environment to be free of that kind of thing. And a fair process must be followed in taking any disciplinary action. You can go on the website and use the words misconduct and serious misconduct for some of the more details in that space. And finally, we have a very, very important point about records. So if you think intuitively, like how many records you're expected to keep as a business, you might think it's not too many, but it's actually quite a long list of things that by law that you're required to keep, and more than you might intuitively think about. So if you don't know about this, pop in the words record keeping into our website and you'll see the details. So the key things is you must maintain proper and adequate wage and time records and holiday and leave records. So one, there's the legal requirement, and two, you need this information to make sure that you're paying the proper amount of wages and proper amount of entitlements. It'll also help you to meet your IRD and your ACC requirements as well. So if you still have problems in having systems and processes around these records, we suggest that you may want to get some professional help or reach out to somebody like a business or industry association and group. But we often see that time after time that the businesses that don't get these records sorted at the beginning have a lot of problems later, especially if they get audited later, or someone like Labour Inspectorate comes to visit you and asks to see where the records are. How are you going to show that you've been paying wages properly and giving the fair entitlements? Migrant exploitation. So while most employers are good, unfortunately there are issues with some employers, and there is an issue about exploiting migrant workers. So the government has an initiative called migrant exploitation, and it's also called the temporary migrant worker exploitation. Some of the recent measures that have come out from that is there's a new visa that's come out, which supports migrants for up to 6 months, called the Migrant Exploitation Work Visa. That allows people who are being exploited to come forward and raise complaints and have a special visa so they can stay in New Zealand longer. And also better ways for them to report migrant exploitation. There's a dedicated phone number, and there's a free interpreting service and a web form. And More information is on the Employment New Zealand website, entering the word migrant exploitation. I'm sure the our stakeholders listening to the webinar today are good and fair employers, but maybe it's good for you to know just to share this information in the community. Fair pay agreements, that's a major thing which is on the cards coming up and likely to affect sort of the payment structures in New Zealand. So I'll just run you through that. Government has introduced fair pay agreement legislation into Parliament, or we call it FPA. It's expected to commence shortly after the bill is passed and anticipated to be at the end of 2022. So not too far away. And it will bring together employers and unions within a sector to bargain for minimum terms and conditions for all employees in the industry and occupation. So you can go to, this time you'd go to the MB website, mb.gov.nz, and pop in the words fair pay agreements just to see what is likely to be coming up. So resolving employment problems. Now, this is a key thing to keep in mind. In employment law, the expectation is that both parties should try and resolve problems as soon as possible. And this is something that's really important to try to do when it's practical, of course. So the information that you'll need is the steps to resolve and following the agreed process. So this information is available on the Employment New Zealand website. Let's go back. Now, sometimes you might find it a little bit difficult. If you had a look, you're not sure exactly which pathway or which way to go. That's fine. Just give us a ring and then we can help you, guide you through what the pathways are and what the right options are. And I'll give you the contact details for our helpline at the end of this talk. So in terms of early resolution, in terms of resolving problems, we also have a new service called early resolution. And it's a sort of comes, if the two parties have got potential to work something out together, it can be done early and quickly, more informally than mediation. Early resolution can be tried. So it's a free phone-based service, voluntary, can resolve employment matters early, quickly, and informally. It's as an employer, if you have concerns about your employee's performance, or for the employee or the employer, if either feels they have an issue that could be resolved promptly, with a little help from an independent resolution facilitator. So maybe the early resolution team person can talk to both parties and work something out and nip that problem in the bud before it becomes big and resolved on a voluntary basis. The service can also assist with COVID issues. Once again, just pop in the words early resolution into the search bar. Employment mediation services, that's also a voluntary process. That's a step above early resolution. It's more structured, it's more formal. It's when an independent mediator helps the parties work through issues and develop solutions together. Once again, on a voluntary basis. We have a free service that's quick and has an 80% plus resolution rate. So you don't have to use the MB service, you can use another service, but the MB service is free to you because it's taxpayer funded. And it applies when both parties have tried to resolve the issue in a low key way, but they may decide to go to the employment mediation service. And often, if you're wanting to go to the next level in the issues, like if you're wanting to go to ERA Employment Court, they will want to know whether you tried to go to employment mediation services to try your best to try and resolve things quickly. So to get more information here, just pop in the words employment mediation services or mediation. Now, given you a lot of information about things that you need to comply with, but the good news is that there's lots of support and try and make things as easy as we can for you to comply with your legal requirements. So over here in terms of tools and resources, you see a news item from our website. So you can go to employment.gov.nz. You can follow us on Facebook or LinkedIn. And like I said, we have 200,000 followers. It's quite good to get the information in little snippets. We have a newsletter. We have something like 175,000 readers, and we put one of those out, most months of the year. So you can sign up for that for free. You can sign up for the Employment Agreement Builder tool, which I'm going to show you a link to soon. And we also online, under our minimum rights, we have some guides, like a little quick guide for employees to know their rights. And if you're a business, you can download this little booklet, which is about 10 pages long, and it summarizes your minimum employment rights and responsibilities. So here we have the Employment Agreement Builder. Its purpose is to create tailored employment agreements for your staff. It covers what you must do by law and common mistakes and how to avoid them. It was launched several years ago, and we estimated that it's had more than 1 million uses now, because people go in there and they create the template that they want. They pick the go back. They pick the clauses that they want, and then so they pick the clauses they want, and they pick up the mandatory ones or the optional ones, and they download their template, and then they can use it. And they've got a legally valid employment agreement, which is all being provided to them free. That's why it's such a popular service. We also have a suite of learning modules. There's 2 entry modules one for employees, one for employers, and advanced modules in these topics. I'll just skip along a bit now because we're getting short on time. You can see that they're available in these different on these different topics down here. These are the advanced modules, and you can go to this e-learning site, or you can go to the Employment New Zealand site and click on the link on the home page, which talks about learning modules. This is really essential information for all employees and employers, and we really highly encourage that you check them out and complete them. They each only take about 15 minutes, and it will really help you and your business and your staff. So if you have more information, remember to contact employment.gov.nz. Like I said, we've got all sorts of information like COVID information, the minimum rights for employees, and under that you'll have links to lots of translated resources. And keep in mind to visit our website for help, for general inquiries, service centre. We've got interpreting service for quite a lot of languages, and you can call us toll free on this number, 0800 20 90 20 toll free. So.
Kia ora, Vinod. That was great information, support for employees and employers. So thank you very much for your presentation. We do have a few partai, or one partai, and that is, no, we're not going to do that. Sorry, I thought we were.
Sorry,
Ange is
Robin,
back. That's okay. No,
that's
fine.
my mistake.
That's
yes,
okay.
I just wanted to, I'm just super conscious of our time. So Vinod has shared some fantastic information, and actually before the session sent us some frequently asked questions should we run into this case where we didn't have enough time. So I have popped them in the chat there. What they are is probably Vinod's most frequently asked questions with links to where you can access that information on the Employment New Zealand website. And if I can encourage you all to go there and have a look anyway, because it is a wealth of knowledge there. So I just want to pass on my thanks to Vinod and his team from Employment New Zealand for joining us in the Tairāwhiti conference. It's been wonderful to have you here this afternoon. Thank you for taking us through the platform of Employment New Zealand. It's like I said, if I can just encourage you, just go there, have a read through. The Learning Centre is fantastic. Sign up to the newsletter so you can keep up to date with information there. So thanks again, Vinod. Thank you, Robin, for joining me in this session. We are going to be with the team at business.gov next at 1:45. But listen, I just want to quickly mention, if you do get stuck and you want to know where to go to access support, Robin is your one-stop shop in Tairāwhiti of connections. So she will be that conduit to help you find your next step of support. Digital Boost is here to help you on your transformation journey. And if you would like to join us on our platform, we have a super easy sign up process, which I'll be taking you through this afternoon in our last session at 2:30 if you'd like to join us. That does bring our session to a close. Thank you to our attendees in the webinar and those who joined us on a live stream. Thank you, Robin, and thank you again, Vinod. Have a wonderful afternoon,
Thank you, everybody.
Thank you, Bernard.
Bye-bye.
Kia ora. Bye. Ka kite.
Bye.